end-of-life medical care that can be provided by physicians?
Be happy to. The underlying principle of the Montana Rights of the Terminally Ill Act is that it is the patient who should decide, assuming the patient is competent, assuming the patient has made his wishes known, and assuming the patient is terminally ill. So under those circumstances, existing law that's been in effect for about 12 years, as I recall, or more than a decade, allows the patient to decide, for example, to withhold food and water, even though it's understood that that will lead to his death. It allows the patient to refuse medical treatment. Very often doctors will go to the patient and say, you have this option. This may be something that has some uncomfortable side effects, but you have this option medically. And it's up to the patient to decide, even though that might prolong his life some incremental amount. It's up to the patient under existing law to say, that might be fine for someone else, I choose not. It's also, even taking it one step further, legal under Montana established law for the patient who has already been treated, who already has been intubated, or has a respirator attached to him, or is attached to the IV bag. It's legal for that patient to say, I've had enough. It's my life, my death, and my suffering. And I, based on my own values, my family values, my spiritual values, the circumstances of my life, it's my right to say, I've had enough, and I like this medical intervention removed. And so Montana law, Senator, already recognizes the right of Montana citizens to say, death can be hastened in my own judgment if that's the decision that's right for me.
Follow up, Mr. Chairman.
Follow up?
The Rights of the Terminally Ill Act has been in place, as you mentioned, for almost 12 years, and basically the doctor can remove the tube from the patient or withdraw the life-sustaining medical treatments. And my question for you is, are you aware of any abuse that's been reported from either doctors removing these tubes or these life-sustaining treatments from the patient, or relatives or loved ones hastening the death against the will of the patient?
No, sir. This has been studied ad infinitum in Oregon, as you might know, for many, many years. And there are always anecdotes that are trotted out, but the considered judgment of all the Oregon health officials is that that abuse has not occurred. And in addition, we recognize that in the existing law, doctors are under some very severe penalties if they abuse this law, both civil and potential criminal penalties. So those are already in effect to protect the patient. I might add, and perhaps this is germane to your question as well, Senator, one of my clients during the course of the case, during a particularly agonizing time for himself, asked me very plaintively, why should someone else have the right to tell me, we don't think you've suffered enough, when it's my suffering and my life and my death that's involved? I think that's the perspective behind the Terminally Ill Act.